coffee and get settled in. We are. Have you ever heard of Guardians of the Galaxy? Okay. How about the League of Honor? Well, we are the League of Esteemed and Learned Counsel here at Forth. So my fellow ladies and gentlemen here are the League of Esteemed and Learned Counsel. So we're going to clarify all the remaining questions that have to do with PFAS and PFAS. As you know, most of it's pretty cut and dried. Everything's very clear. We know what the problem is. We know what it's going to lead to. And we got it all covered. So here you go. Say again? Amen. 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 I like the amen corner back there. That's good. So we're going to kick it off and get right into it so we can get out here exactly at 12 so you can get out of your room and not be charged another day. So the thing I want to start off with, I'm sort of the interlocutor here. I don't really know much about this, but I have some experts here. The thing I want to start off with is what is everybody's reaction to whatever it was that EPA did in April. So you got several topics to choose from there. Lauren, you want to hit it first?
Oh, gracious, sure. So my reaction generally to what EPA has done in April is that they have earned their paychecks. And is it not on?
Maybe
put it a little closer.
Right into it.
Okay. So my general reaction is that EPA has earned their paycheck in the month of April and probably March as well. Well, gracious, and May, the last 3 months. So I think that it's a really great kind of culmination of decades of research. So I'm excited about these developments, particularly the drinking water standard. I think that is been long awaited and anticipated. So I'm anxious next to see whether we're going to, get some groundwater and soil regulations. But I'm particularly most excited about the drinking water standard. My thoughts.
Somebody else want to contribute on that topic?
Sure, I can talk just about the EPA, what EPA has done. As a former EPA official, I can tell you, yes, that these activities have been in the making for a long time. They span multiple administrations. And there was a push before the Congressional Review Act would kick into play, surely to get some of these major kind of economy impacting rules issued. On the CERCLA designation, I can tell you that litigation is coming on that. In particular, EPA didn't really take costs into account too much directly for a rule that's going to have substantial impacts on the economy. So I guess on the one hand, I don't know if all of us up on this panel would be pleased if the rule was overturned, or if we'll be working with clients for decades if the rule stays in place on all the litigation that's going to happen once the CERCLA wrecking ball swings into action and cost recovery and contribution actions start at sites potentially around the country. And on that point, EPA has its enforcement discretion policy, which it's issued, but remember that applies to EPA. That doesn't apply to states, that doesn't apply to tribes, doesn't apply to private parties, and so the impacts of that rule, span far beyond the reporting requirements that are going to be triggered under Section 103. And so that's something, just keep your eye on that. Like I said, the litigation will be coming.
It's just sort of like an explosion, and you see all the things fly off in different directions, that are going over here reporting, more CERCLA sites, other things. Michael, can you give us your thought, particularly focus on their enforcement policy, if you don't mind?
Absolutely. We could spend all day answering that question. There's so much to say, and I'm going to defer to some of my colleagues who have a Florida-specific practice to talk about the 62-780 implications and what this means for due diligence and how phase ones are construed and drafted and utilized. But I do want to say this about 62-780 in Florida. The federal action really clarifies the mind. And for a number of clients that we have, the question will be not so much what is the benefit of deferring testing in a due diligence context, but rather how quickly should we turn and embrace a likely release in order to take advantage and lock in the 70 part per trillion provisional GCTL that currently exists on the books. So you can lock that in place and not have to deal with the 4 parts per trillion standard whenever the legislature and DEP get around to adopting for
Do you think
PPT
you're
to
gonna be
follow
able
the
to lock that
MCL.
into place, or that-
Well, I know for a fact in Miami-Dade County, having spoken with the chief of the pollution regulation section and looked at the code provision itself, there is specific language in Chapter 24, and there also is in 62-780 that allows you to grandfather in existing CTLs where you have an approved remedial action plan order. So if you get a RAP order or its equivalent in a jurisdiction where you have a delegated local pollution control authority, then my legal opinion is that standard will be sacrosanct and not subject to being overturned once a new standard gets adopted at the federal level that's less than the 70 PPT combined standard for PFOS and PFOA.
would that be subject to a reopener?
No.
Another whole question.
No, that's a whole other question, but based on the analysis that we have conducted to date, the purpose and effectiveness of the grandfathering provision in Chapter 24 at the Dade County level and 62-780 at the state level is to protect the integrity of the cleanup and insulate it against any reopener that might otherwise be in the NFA. In other words, it wouldn't be a reopener event because you would have closed out pursuant to an approved standard at the time.
Good to know, good to know. Robyn, what do you think?
Yeah, I was just going to add on that, on Michael Goldstein's point there. I mean, there's precedent for that. So remember when the MCL for arsenic was 50 and it dropped to 10. So, DEP and a number of county agencies have agreed on previous site closures that the 50 applied to that specific closure and was not subject to reopener. I don't know what DEP or the counties are going to specifically say to that, but I think that's a very interesting point, Michael. And although 70 doesn't sound great, it's much better than 4 PPT.
Talk a little bit about what you see DEP reacting to this and what they're doing and thinking from your interest.
From my practice is more transactional, but I've had discussions with DEP on what their reaction is and how they're evaluating the activities by EPA in April. And they've had lots of meetings, and I don't think anybody from DEP is here, but they have not determined a specific path forward or time frame yet. I mean, there are requirements in the drinking water administrative code regulations to have to adopt any MCLs that are promulgated, have to be at least as stringent as what the federal EPA has adopted. But my sense is that DEP staff is trying to figure out, they're having meetings at the secretary level and the governor level to determine next steps and time frame. I've asked those questions, Frank, and have got limited answers. And other than to say, well, that's a really good question, because I also asked the question is, okay, so if you're not going to promulgate any rules, complete rulemaking by January 1, 2025, as indicated in the Florida statute, I know you're going to sit back and wait and see, as Greg said, if there's challenges to the EPA final rule for drinking water for PFOA and PFOS, what are you going to do on enforcement during this time frame? Do I have to, if I'm waiting to see what the state's going to adopt, and we know that under the Florida statute, there will have to be legislative ratification of any standards in Florida that are drinking water cleanup target levels for PFOA and PFOS. What about now? What do I do between now and then? Do I need to worry that you're going to be asking at the very last moment on my site closure that I have to sample for PFOA, PFOS, any of the PFAS constituents? And the answer that I got to that question to senior DEP counsel was, that's a really good question. We don't know the answer to that yet. So as Frank said, we have all the answers, maybe, but you know, there's just more questions than there are answers at this point.
We were promised, you know, we talked about this in detail last year with the new legislation and the statutory deadlines to adopt standards in Florida. You know, we were promised by everybody, the legislature, DEP, that was going to bring some certainty for the entire industry that's sitting in here. And Frank, to your original question, what does the EPA flurry of action do? Just creates greater uncertainty. And I think, to Greg's point, there will be challenges. There are challenges pending very, very quickly. Probably going to delay, ultimately, DEP's adoption of these standards. Are they going to have to go back to the legislature to authorize delay? Are they going to initiate rulemaking when everything is under litigation? Uncertainty, but...
Yeah, the litigation could, on the federal level, could put everything kind of on hold, but then the Florida statute calls for them to probably have something proposed by January 2025, and then the legislature has to revise it, and they aren't going to have it ready to go if they start in January 25. So the legislature looks at it in 26, they boot it downhill at least to 27, because the big question is going to be how much is this going to cost. So in Florida, we have like a couple of levels of, but that limitation on liability only applies to the public, to local governments and public water supplies. It doesn't apply to our private clients. They could go after them in the meantime. Nick, I want to introduce Nick. Nick is a New York lawyer who is joining us for the first time. We've done some work together. And do you have a perspective we'd like to hear from about what you think is going to happen in New York?
Well, not only in New York, I could tell you, so New York's a little bit ahead of the game than in Florida. New York designated PFOA and PFOS as hazardous substances in 2016, and they actually have a state drinking water standard of 10 parts per trillion for both of those substances each. So they're a little ahead of the game. I represent 3 airports, a fire station, fire training facility, all of which are Superfund sites in New York. Also represent one in California, all of which sued and are in the MDL. But my reaction to this effectively is, oh boy, right? So what does this do? What does a hazardous substance designation do? Before the designation occurred and before it becomes final, in order to sue and recover, you need to prove negligence, right? Generally speaking. What does that mean? Someone needs to have acted unreasonably in discharging material. So for example, you go to a fire department. Did they act unreasonably by using firefighting foam that either they were mandated to use or otherwise? That's a tough pull, right? Now under CERCLA, hazardous substance designation, the CERCLA, I'll call it Pandora's box, is now opened. What does that mean? That means now that fire department who used the foam actually has strict joint and several liabilities. So what does that mean? That means whether they acted unreasonably or not doesn't matter. Whether they contributed a small portion to a larger quantity of PFAS in the subsurface doesn't matter. They need to pay for the whole thing. How are they going to do that? Volunteer fire departments. So whether you represent a client that is, for example, a fire department or someone potentially downstream of a fire department, it is imperative to do really 2 things. 1, get your ducks in a row on funding. How do you do that? There's really 3 avenues of funding. 1, grants, state, federal. 2, insurance, which I'm going to talk about later, which frankly I think has been overlooked significantly. There may be pretty good avenues to recover on insurance. And 3, litigation, whether it be in the MDL or CERCLA litigation. The second thing that a client may want to do, and really should do, is retain a really good environmental lawyer, like my colleagues here, and retain a really good environmental consultant that could do the forensics, very important, that you've seen in a bunch of different presentations. That forensics is so important because PFAS, as we know, is ubiquitous. So if you could point to your neighbor, or you could point to another source, or atmospheric deposition, or background level, or something else, that's the way how you reduce your liability, both from that perspective, and also you can mitigate your liability by going out there and getting the funding I mentioned. So that is essentially my reaction from
That's good. I know you're involved in the MDL litigation. Can you enlighten us about what the status of that is, the multi-district litigation? First, explain what it is, if
Sure.
you don't know, and then kind of tell us where it stands.
So my first lawsuit I brought was in 2018. It was on behalf of the town of East Hampton on Long Island, east end of Long Island. They have an airport. The state DEC, very similar to DEP here, designated the site as a Superfund site because private drinking water wells down gradient had impacts. The town, extended the drinking water main, and then ultimately we found out, of course, that the airport and also some neighboring properties contributed. So we sued, and then after we sued, the manufacturers sought to consolidate all AFFF lawsuits throughout the country into one centralized jurisdiction. So that was all moved to South Carolina, District of South Carolina. So there's now thousands of cases that have been commenced throughout the country that all have been consolidated in South Carolina. And yesterday we heard about some settlements that occurred. 3M settled, DuPont settled. 2 recent settlements were announced. Tyco was a AFFF manufacturer, and BASF, which was formerly Ciba-Geigy, they were a constituent, a manufacturer constituent that was put into AFFF.
What are the numbers on those settlements that have been reached?
Overall, combined, 3M's putting between 10.5 to 12 billion. DuPont's around 2 billion. Then Tyco is in the $500 million range, and BASF is in that range as well. But that's all for public water suppliers. That doesn't even touch what the judge calls dirt claims, Superfund claims. So there's going to be a lot more money coming down the pike. As people referenced, yesterday, there's just not enough money in the world to clean up the world, right? So that's kind of where we are.
Lauren, can you add some things to that? I know you're involved in that litigation as well.
Yeah, absolutely. Is this on now? Hello?
This is on.
Okay, let's switch. All right, thank you. Just to add a couple of more points about the litigation, it's interesting because in the transcript to the fairness hearing that the federal judge oversaw in order to approve the settlement agreement, there was a fairness hearing in 3M and a fairness hearing in DuPont, and those are basically to the judge and the party's opportunity to explain why the settlement agreement is fair, and for the judge to approve the settlement agreement. In the 3M fairness hearing, which took place in February of this year, the judge specifically said that he thought that the settlement for between 10 and 12, 13 billion dollars was fair because there were still outstanding personal injury claims, still outstanding property damage claims, and so forth, and they didn't want to bankrupt the company. So they want to keep, 3M, DuPont, presumably BASF, and others sort of alive so that they can keep milking them for money, for lack of a better analogy. So it's really interesting that the judge acknowledged that during the hearing, that we can't sort of extract all of the money in this settlement agreement for the public water suppliers because there's so many other claims in that MDL to handle. And he didn't say whether or not the personal injury claims would be next or not. I've been combing the docket and the filings and the transcripts. So I haven't seen personally, and maybe others have, I haven't seen an indication of which section or group of plaintiffs will be handled next, but a little
Thank you
color
for
that might be added.
Yeah, thank you for that. We like to have this be interactive, so if you have a question or a comment or correction, just raise your hand, and if I see you, I'll try to call on you. And it works best if you're participating with us.
Frank?
Go ahead.
I'd like to add two
good
comments,
switch.
two observations.
Oh.
Is this on?
Oh, perfect.
You have to be right.
I'd like to add two observations to Nick's comments to bring the litigation discussion back to Florida. Because I think that there are some takeaways here for Florida practitioners that are important in a litigation context to move beyond maybe litigation-induced paralysis. We already have in Florida strict liability. Yep. We're not waiting for the CERCLA listing to kick in. We have a statute called 376.313, which creates strict liability for any release of a regulated substance. So there's that, but the funding mechanisms that exist at the state level are real, they're significant, and they can be used to underwrite and subsidize and move forward state-based cleanups under the Florida Brownfields program. There's nothing peculiar about PFAS that takes it out of eligibility for voluntary cleanup tax credits. Currently, the state is funding tax credits at the rate of $35 million per year statewide in perpetuity. That's a lot of money. And as of 2024, the magnitude of application to that tax credit program left about $11 million of capacity, which presumably will be absorbed in the coming year, and we may in fact need more tax credits in the future. But as it stands right now, there is a viable funding mechanism beyond the three sources of funding that Nick mentioned, all of which are valid, but there are other tools and resources that are available today for developers, for communities, for local governments, for not-for-profits to move these cleanups forward, and we have good tools available to do so, transactional tools, regulatory tools, insurance tools, and the like.
So Michael, as a brownfields practitioner, you leading that charge, what do you say to the kind of PFAS naysayers that if they let that into brownfields and let it essentially monopolize brownfields, open the floodgates, that $35 million that we were all so thankful for, and we actually have an excess, as you said, some capacity now finally, we're beyond the years where we had to wait 3 years, 5 years for a backlog payment. What happens if PFAS floodgates open and kind of, I won't say bankrupt the brownfields program, but we go back to be horrifically underfunded?
Well, that's a great question. So I'll say two things. Number one, we don't have to let PFAS in because PFAS is not currently excluded. They're in.
Yeah.
There's no PFAS exclusion written into the statute. So if you have a contaminant that's recognized in Florida statutes, which PFAS is, even though there isn't a formally promulgated SCTL or GCTL, you're going to be able to apply for tax credits and get funded. That's number one. Number two, from a public policy perspective, the more the merrier. The more contaminated sites we can get cleaned up, the better. We're agnostic with respect to the type of contaminants that get cleaned up. We just want them cleaned up. We want more underutilized, challenged sites to be returned to productive use. Mm-hmm. We want more public health protection. We want more job creation. And the history of the Brownfields program and the voluntary cleanup tax credit program in particular, going back to 1998, is that it is a living, breathing, evolving thing that over time reacts to respond to the need of the moment. Originally, the tax credit program was funded at $2 million per year. And when that wasn't enough, a number of us in the room sitting on this panel went to the legislature and said, we need more. So the legislature came back and said $5 million. Yeah. And then that wasn't enough. So we went back and, Diane knew, we asked for $10 million. And the legislature said, fine, $10 million. And then that wasn't enough. And then they came back and said, okay, $35 million. My expectation is that as a community, we will be able to make the case to the legislature that this is an issue of serious public health concern, environmental concern, and environmental justice concern. And if we exhaust the $35 million cap, the legislature will find more money.
Yeah, both of you, Ron and Mike, the other sort of aspect of cleanup benefits that's often overlooked is the voluntary cleanup agreement for dry cleaner sites. And we're expecting a lot of dry cleaner sites will have this problem. So that's another route to getting into some of the benefits. It's not used all that much. I don't know how often you've seen that, but if you have a dry cleaner site, think about using the voluntary cleanup agreement route. You don't have to go through the BISRA, you don't go through a designation, and I think there's going to be a lot of, don't you agree that there'll be a lot of dry cleaner sites?
Well, just last week, I wrote to DEP to see if they would accept a voluntary cleanup agreement under the dry cleaning program to fund a PFAS release. It's under consideration.
I don't see any barrier to it at all, so.
We have
Robyn?
a question from the audience.
Oh, good.
Hi, Frank.
Yes.
So I want to talk a little bit about the Brownfield program. I'm the Brownfield coordinator for Hillsborough County, and I can see sites coming in with PFAS contamination, but they have to be a site that had a PFAS discharge. I don't think that it would be appropriate to use the Brownfield program to go into a site and evaluate a property and clean up the PFAS on, that property with the VICTIC money if there was no discharge there. So it would have to be a site that had a discharge on the property to be a brownfield site, and they would have to have a redevelopment plan, and the property owner has to be not the one who caused the contamination unless that is changed by the legislature. So I just kind of wanted to throw that out, so that way we wouldn't be spending all the technical resources and all on assessing PFAS, evaluating where it comes from when it doesn't come from this particular site.
It could be, in other words, it could be a site adjacent, just like any other adjacent source. That's what you're saying. Brownfields cleans up, you're cleaning up the source property.
Correct.
That's your point. That's a
Yeah,
good
you
point.
can get some
That's not
credits if
correct.
there's a discharge adjacent for
Yeah.
affordable housing and things like that. So you still can get brownfield incentives by becoming a brownfield area. But as far as the cleanup goes, it would have to be a discharge on that property by someone who didn't cause the discharge. So you would have to have a redevelopment plan for this property that had biosolids spread on it. That would be eligible.
And most of the time, that's going to be a developer who's coming in and developing that property who did not put the material there. Talk a little bit about the liability limitation contained in the Brownfield statute, and because that's something that's important on this topic too. I don't see any reason why the Brownfield's liability limitation wouldn't apply. Can you speak to that for a minute?
I usually leave that to the attorneys. I'm the geologist, so you go ahead and explain the liability protection. It's in Florida Statute 376.
Yeah, under the Brownfields program, if you have, if the site's been designated and you've entered a BISRA, then the entity who enters the BISRA receives a limitation on liability for certain types of other cleanup actions, but also for off-site property damage, not for personal injury, but for off-site property damage. So there's a very valuable liability limitation, which at least would help you on the property damage from your neighbor type of lawsuit. As far as I know, that hasn't been tested yet, but I don't see any reason why it shouldn't hold up. So the Brownfields program isn't, the next thing I'd like to ask about that, and I'll ask the panel and the audience, the important point here is as to cleanup, just as to cleanup, not personal injury suits or that kind of thing. But in Florida, under 62-780, is PFAS treated any differently in groundwater than any other contaminant? In other words, under our statute, if you find it's above whatever standard we want to put it at, and you contain it on site, or you have options if it's off site, it should be pretty much the same thing as any other groundwater contamination. Don't you agree?
Yes, I absolutely agree. It should be,
Yeah.
but my sense is that DEP is trying to figure out, their policy approach on it. So there's a higher sensitivity on PFAS, and I'm saying in the context of seeking a guidance letter or a comfort letter
Yes.
from DEP. That is a statement that I've made to them that, this is not any different than PCE, MTBE, it's all the same. Why are we having a higher level of concern on that? So
The
the
higher
emphasis
level
is
of-
it should be.
Yeah, the higher level of concern comes from the level that you have to clean up to. That's how that comes into it. That's the risk, right?
On this particular situation, I was trying to seek a guidance comfort letter that says we've demonstrated on this particular property that the PFAS groundwater impacts that were identified are coming from an off-site source. And therefore, in the proposed acquisition and development of the site, as long as you properly handle dewatering and not exacerbate existing site conditions, my client shouldn't have liability for that. Can we get your standard comfort letter that we're used to getting from the Florida Department of Environmental Protection? And it doesn't matter where the source is, right? As long as I demonstrate it's not coming from my site.
Why should it be any different?
Why should it be any different?
Yeah.
But it is different.
Yeah.
I mean, the situation that Laura Lockett, who's usually on this panel, and I are dealing with is that they do not want to issue that comfort letter until they have identified the source at a nearby airport, or we believe the airport, to determine more information on where the source is before they issue a comfort letter. So my emphasis is, I agree with you, Frank. It absolutely should be. Poor Michael Goldstein's freezing here. It should be, but I feel as if FDEP is treating it differently at the moment because they're working to figure out their policy approach.
Frank, you're talking about a heightened standard, that we're all living under right now that's creating all this uncertainty. I think specifically for purposes of 62-780 closures, we're going to have to move to a lower standard, quite frankly, when it comes to PFAS. The background study is a perfect example there, right? How are we going to get sites closed when we do finally have a cleanup standard? We add PFAS as a contaminant of concern to many sites. I don't think there's going to be a push to make it on all sites, but then we expand the investigation. We've otherwise got delineation. We otherwise have plume stability, and if the PFAS is ubiquitous, as everyone believes it may be, it's really going to complicate 62-780 closures. It's going to complicate Michael's brownfield closures. We'll get to that. What is the ultimate remedy here in Florida? But for 62-780 purposes, it's going to be a delay. It's going to be an expense.
And that's why I like to stress that it may make more sense to embrace cleanups now when your bogey is 70 parts per trillion than waiting for 4 parts per trillion.
Yeah, I'm ready for DEP to weigh in on I mean, I know it's in the statute, and, I respect that's right, but I want to hear their interpretation of that too. So
Well, who knows?
we'll get that soon.
In fairness to them, I can see why they're hesitant. I mean,
Absolutely.
it's a hard thing. Well, Nick or Greg, would you like to address issues in your state on how cleanup will take place? Does it really change how you clean up a site? I know New York's ahead of the game a bit.
Not really.
Yeah.
I mean, it's the level, as everybody has said.
Yeah.
And the uncertainty surrounding on, do you actually have to get to that level? Are there site-specific cleanup objectives that you could implement? In New York, the groundwater standard is actually 2.6 parts per trillion for PFOS. So it's even lower than the MCL. No one's getting that low, right? Interestingly, the surface water standards in New York, I don't think Florida has surface water standards, are like 200, 400,000 parts per trillion. I haven't seen any PFAS in surface water at that level, at least in New York. So that's somewhat comforting because you limit a significant receptor. But I think the big driver to all these cleanups is drinking water. So if you have drinking water wells down gradient, that's going to really drive a regulator's push to clean up to very low standards.
The question I have for the whole group that may have heard through the grapevine, do we know whether the University of Florida risk assessment group that does so much work for EP, are they looking at PFAS? Have they been contracted to do that?
There's a couple of questions from the audience.
Yes, great. Who? Go ahead.
Hi, I'm curious to hear what the panel thinks about risk tolerance on behalf of the clients in land acquisition. Without a known release, do you think that there's going to be a lot of clients that will head towards testing anyways, just to see if it's present or not present?
Did you understand that?
I didn't
think so.
I don't think we can understand
Yeah,
you.
can
Can
you
you stand
repeat
up?
the question?
Stand up and repeat the question for us.
So from a land acquisition standpoint, do you foresee your clients being more risk averse? So say there's not a known release and a known source, do you think there's going to be a lot of people prior to land acquisition wanting to go through with testing to see if it's present and to try to cover themselves?
Yeah, and that is a very good question. Did you
ahead.
understand the question?
Yeah, go ahead.
So my experience with my clients is, that there is a question of the environmental risk on these various sites when they're acquiring land and proposing their development. But my personal experience is, unless there is a specific reason to test, and we're going to have that question at the end of our panel, and everybody's going to give you their take on it. But to answer your question, my sense is that clients are becoming much more sophisticated, and that they are aware of PFAS issues, and I don't think they're planning, my personal experience, planning to test on every site just out of the box. But guns blazing, as Nick had said, with guns blazing, we're just going to sample everything. Or, are we going to be, in my favorite phrase, strategic and surgical, and have a good reason to test? And, based on the site and potential sources. But, I will throw out, and that we'll talk in more detail later, that if you're doing a large development on a 60-acre piece of property, and you're going to be grading the site, and you're going to have a 10-acre stormwater pond, and you're going to have a significant dewatering activity, that in itself may be a reason to test if you have a nearby source or a possible source. So hopefully that answers your question.
The way in which due diligence isn't evolving based on the evolving knowledge base from a scientific perspective is continuing to surprise me, and informs this discussion this year in a way that it didn't last year. The question that Robyn just referenced, which we'll address as a panel at the end of the presentation: do you test, do you not test, do you recommend to your clients that you test or not test? We'll get to that. But what I've now seen is that even where there is a basis to test, and that's expanding, right? Typically, historically, it's been airports, right? Wherever AFFF was used.
Fire station.
And fire stations. Now, there are a few more Crime Stopper clues that we add to the mix. C&D landfill sites, not expected. Agricultural sites where you've had the application of biosolids, that is now front and center. And dry cleaning sites. There's ample evidence at the DEP level and a lot of evidence in Miami-Dade County that just about every single dry cleaning site will have PFOS or PFOA or a combination thereof. So 9 times out of 10 in a commercial redevelopment context, you are going to be proximate to one of these 3 types of uses, if not one of those 3 types of uses specifically as part of that redevelopment. The point I'm trying to make is this, that you are going to have some sophisticated buyers who say, and this was the surprise to me, notwithstanding the fact that there is a demonstrable basis to test, because we're buying and redeveloping a C&D landfill, or we're buying and redeveloping a dry cleaning site, or buying and redeveloping a former ag site where biosolids were applied, we are not going to test because we don't want to upset the apple cart. This site has been well positioned for redevelopment. Some of these questions have been asked and answered, or we don't think that the regulators are going to ask them once we move forward. So we don't want to know, even though We have a lot of experience in this area, and we have sophisticated counsel and consultants who are telling us that if you look, you're going to find it. That, to me, was unexpected, and I think we're going to see a fair share of that going forward from the more sophisticated clients, developers and lenders.
Also, if I could just add, so when you do a phase one, obviously you look at historical information associated with the property. If there was ever a fire suppression system at a property, you know, that's very important, and often that's not typically considered. One other thing, AFFF wasn't only used, for example, at fire stations. It wasn't only used at fire training facilities. It was obviously used in response to emergencies. And we saw earlier today the source analysis where Geosyntec found AFFF use at a site that they didn't anticipate, and it actually caused PFAS contamination. What I have found is that due diligence via historical newspaper searches has been immensely helpful. And that's obviously overlooked. It's not part of a typical phase one analysis. So something to consider when you're doing that due diligence for transactional purposes and frankly also litigation and otherwise.
And insurance coverage. Can be a question,
Insurance coverage as well.
which we'll get back to too.
Sounds good.
There's a few more questions from the audience.
Go ahead.
Hi, I had a question related to the proposal to get locked in at the 70 PPT provisional cleanup target levels. And does the panel or Michael, in doing your analysis, did you have any concerns about presumably if DEP comes back and promulgates a final cleanup target level rule that is lower than that, does that then leave your client vulnerable to essentially a citizen suit under 43412 Florida statutes, where they can allege that even though DEP said, okay, you're good, closed at 70 PPT, if they set it lower than that, essentially that's admission from DEP that it should be lower, and yet they're not requiring the property owner to take it down any lower than that. Had you considered that? Is that a concern?
That's a great question. That's a lawyerly question. I had not considered that, but here's my response, my immediate response, subject to a lot of research by one of my associates when I get back to the office. So 403.412 provides for injunctive relief. And you go, you plead under 403.412 to get an order to compel a government agency to enforce a particular law. Here, I don't think that anything would come of it that would impact adversely on a client, because the remedy had already been implemented. The standard in effect was grandfathered, and thus there would be no relief which a court could grant, because the rule allowed for the closing out of the cleanup at the higher standard. Now, that's not to say that a third party couldn't come in and seek relief under a different statute, like 376.313, which provides for economic damages, right? But that's why, as Frank mentioned, one would also want to proceed simultaneously under the Brownfields program, because that liability provision, which is 376.82 Florida statutes, protects against claims for any form of economic damage, not just property damage, but diminution in value, lost rents, et cetera, et cetera.
Yeah,
that's my response.
That raises a point that we ought to touch on, which I think is lost sight of, and that is, I'm sorry, who would like to talk?
Oh, do you want me to ask my question?
Yes.
This may shift it a bit. My question is related to, does anyone, and possibly Nick coming from New York, have any idea or a finger on the pulse of when EPA will handle and how they'll handle this under centralized waste treatment?
I'm sorry, I didn't catch
The last part of it. Yeah, say it one more time, please.
I'm questioning when, or if anyone has heard or has their finger on the pulse of how the EPA and when the EPA will handle PFAS under centralized waste treatment.
Centralized waste treatment.
Yeah. As far, I mean, I can tell you from New York, what New York is looking to do is actually not. They're most likely, from what I've heard, not going to place standards on wastewater treatment operators, but instead they're going to look to go upstream to industrial sources to try and limit like point source discharges or discharges to sewers, et cetera. That may change. I mean, we're in the Wild West here, so who knows? That's a great question.
Nick, I think that's one aspect of their enforcement policy.
Yes.
To look at the source, ultimate source. Others?
To be a CWT facility, though, you've got to be, typically in Florida, you've got to be hard piped, to a municipal, county, or municipal treatment system. So it's going to fall on those publicly owned systems at the end of the day. They're going to be receiving that CWT treated wastewater. And, we're going to see more potential legislation in Florida this year. It didn't get very far last year, but, the public utilities, private utilities see this coming, and they're going to be seeking, their own liability exemption. And that bill didn't get far this year, but it'll be back next session.
Go ahead.
This is for the panel. Are you hearing anything from the lending insurance industry as what their early positions will be considering limited site investigation?
Is Edwin Baez still here? Edwin? No. Edwin Baez is the environmental underwriter for Beasley Insurance, and he presented on Tuesday. And Beasley, like many other insurance companies, are still in the game, even with respect to PFAS. Some underwriters are more aggressive than others. We've had a lot of success with Beasley getting coverage on sites, even with documented PFAS impacts. And what Edwin said on Tuesday is that it's all very site-specific. If there is a sufficient amount of data, it doesn't have to be all the data in the world for the insurance company to get through its underwriting and feel comfortable about rolling the dice. They will do so. And so it's been my experience, and I think Robyn's as well, and maybe others on this panel, that even where, again, you've got documented PFAS impacts, you can get insurance coverage. It won't always be the case, and more often than not, there are blanket exclusions through endorsement, but there is still a path to navigate to get coverage for acquisition and redevelopment and financing.
And under that approach, the insurance company is going to insure for something worse than you found. If it's more widespread or higher concentrations, which is worth it. I mean, it's worth it to have.
Yeah, I guess the only thing I would say on the insurance piece as well is the pollution, legal liability policies sometimes do have the blanket PFAS exclusions, but one creative approach, we've used is excess of indemnity coverage can sometimes cover PFAS. So if there's a way, so basically it's in a purchase or a merger agreement, there would be indemnity provided oftentimes from the seller to the buyer, and that will have a scope of coverage including various environmental issues, sometimes up to a certain amount. And if you do then get excess of indemnity insurance, in other words, insurance to cover above and beyond that indemnity, it can be possible to have PFAS coverage as part of that policy. So it's always important to look at all of the different policy options that might be on the table, not just with a tunnel vision on kind of the classic PLL, if you want to try and get PFAS coverage as the insurance market evolves.
Nick, why don't you chime in on the insurance?
Sure.
Move to that.
I know we alluded to it earlier. So before I got into PFAS, it was almost universal. There's an absolute pollution exclusion. It's going to be very difficult to get coverage.
Just so CGL policy.
CGL policy, yeah. But pollution liability, different ballgame. This is, of course, post-1986, which is when the sudden accidental pollution exclusion was effectively abolished, and the absolute pollution exclusion came in. To my surprise, in connection with the litigations that I've been handling, I actually got my hands on my clients' commercial liability policies, as well as some of the defendants, including a fire department that I sued. So the airport policies universally that I have seen so far have pollution exclusions, complete, absolute pollution exclusions, with exceptions for crashes, fires, and explosions. That opened amazing insurance, especially under investigation, which at least in New York is considered a defense cost, which is significantly broader than an indemnity cost. So I have gotten insurance companies to fund completely remedial investigations to the cost of $3 million plus. And this is often overlooked with respect to PFAS, remediation, et cetera. In addition to that, I also got my hands via FOIA requests, et cetera, on fire department policies who I have sued. And to my surprise, very similarly, there's a pollution exclusion with exceptions not only for emergency response, which is significant, but also for training, for washing of equipment, et cetera. And so if you have a fire station upgrading, for example, of a drinking water well or of your site or commingled plume, there is significant insurance available from the municipal level, whether it be from airports, whether it be from fire stations. And it doesn't just stop there. I mean, if you go back in time, AFFF was around since the 1960s, so you may be able to actually tap into sudden and accidental pollution exclusions. This is all, the law is very state-specific, so it depends where you are, it depends where the policy was written, et cetera. But the takeaway is do not sleep on insurance. Look at your policies and scrub them as much as you can. I'm doing this work on contingency too, so I think it's very helpful to the client.
This is extremely important because a lot of risk management people in companies and municipalities and even brokers don't understand this subtlety. They see a sudden accident and say it's not covered. But if you take the next step and argue with the carrier that he's saying they're getting it covered, and I believe him, I think it works well. Let me add one little thing about the cities and counties. If you thinking this through, some of the biggest sitting ducks are the local governments, because by my count, they have wastewater treatment plants, they have water supply, they have airports, they have landfills, and they have biosolid disposal going back decades. So they have at least, what is that, 1, 2, 3, that's 5 different, and that's just the ones I can think of off the top of my head. But he's talking about that these are coverages that might be available to the municipal, the locals in these contexts. Extremely important. This is something that is a gigantic physical benefit if it works for the especially for the municipalities. Because the average, well, and even so, you know, a lot of contracts, they're contract runners of airports. So they may have coverage which apply to them as well. So that's a whole big thing.
Frank, if I could just add one thing.
Yeah.
The reason why it's so important, I mentioned before the multifaceted funding approach. So the 3M and DuPont settlements, it sounds like a ton of money. We said before, you know, it's really not. That amounts to approximately, when you boil it down, a public water system's cost of around 10%. So they're only getting around 10% from 3M DuPont. Where's the 90% balance coming from, right? We got to find. It can't just be the taxpayers that fund this stuff.
And I was just going to say my takeaway from what Nick said is ask your client for their insurance policy, their CGL policies, if they have a pollution legal liability policy, but the CGL policies, make sure they're saving those and have someone go through those in detail. So ask for those policies. And were you getting the policies actually from the various entities, or were you getting the policies from the insurance companies as part of the litigation?
So once you get one policy and you find that an insurance company, you have to go back, right? You could go all the way back to the 1960s, so there's some archaeology that goes into it. Once you know that there was an insurance policy issued by an insurance company, you actually can ask them, and to my surprise, they're very cooperative.
That's what I wanted everybody to hear you say.
To supply as many policies as they have in their possession. So yeah, thank you, Robyn. That's a good point.
Yeah, that's a tremendous pain in the wazanga to go through all that, let me tell you.
It is.
Frank, one last observation about pollution legal liability coverage and the PLL policies. It's not infrequently the case that even where an underwriter will not provide cleanup coverage for a known contaminant, they will provide third-party coverage for bodily injury claims and property damage claims. So as we're advising clients out there, whether they're private sector clients or public sector clients, about the availability and the efficacy and the utility about pollution legal liability insurance, just because it may seem unlikely that we will be able to get cleanup coverage doesn't mean that there's no value in pursuing coverage because of the protection against bodily injury claims and property damage claims.
And there's that aspect of, if they know about it, if it's it turns out to be bigger or strong or higher levels, that could be covered even for cleanup. And of course, defense costs are staggering in this kind of thing. Any other thoughts on the panel, y'all? Want to chime in?
Not from me.
Okay. Well, I think it's time for us to transition to the topic of transactions. We've kind
Just
of
one more question here.
Oh, good.
Yeah. My question takes us back to the grandfathering of the CTLs and the determination of HRECs. When we do the due diligence and determine the HRECs, we also look at the concentrations under which closure was granted. And if the concentrations exceed the current CTLs, would identify that as a condition. When closure is granted, when CTLs are grandfathered in, how do we handle HRECs in that situation? Do we identify them as a...
Did anybody follow that?
I did.
Yeah, tell us, go ahead,
Go ahead.
Michael.
So I think if you have, my position on that would be, my legal position, understanding the current ASTM standard, is that if you have a regulatory closure at the time, and if you have regulatory closure at the time, irrespective of what may happen in the future with respect to the cleanup target levels upon which the closure was granted, if, as a consultant, you can be assured that the grandfathering provision that I've represented to exist does in fact exist, then that condition gets characterized as an HREC.
Which is a historic recognized environmental condition.
That's right.
Yeah.
And just to add to that, not in the PFAS context, but generally, I had a situation recently where I represented a client that was looking to buy a piece of property in Florida that had a former crop dusting landing strip and a former pesticide container landfill, and the phase one that I was given to review characterized a situation as an HREC based upon a 1980, I think it was 86 Department of Environmental Regulation closure before there were any standards for, soil standards for toxaphene and related OCPs. And so it was noted in the phase one that it was an HREC. But, there, in my opinion, there should have been also a statement in the phase one that said, this was closed when there were no standards at all, and the residential, and they used, I think, 65 milligrams per kilogram for the cleanup target level. For toxaphene. And the residential standard, I don't remember exactly what it is, help me out, Christine, but it was it's like 0.8 now, and my client is building single-family residential homes there. So I think in the same kind of context as PFAS, if, under Michael's suggestion, which I think is excellent, if the 70 PPT, you get a site closure and you do your due diligence later, and 4 PPT becomes the groundwater cleanup target level in Florida, it still would be an HREC, but you should go on and advise your client, the other background information on that. So
yeah, and there's a tricky provision in Florida law when you're selling a residential property that you have an obligation to disclose. You have an obligation to disclose a material latent defect. So if you're selling residential property, a part to advise the client on is, will I have to disclose this will you have to disclose this to your residential buyers? So that's a tricky one because the number is in fact lower today. So is that a latent material defect?
Well, to tie a bow on the story, we sampled.
Yeah.
And in the areas that the client is purchasing and developing, and then another property owner was sampled there, and we didn't detect anything.
Well,
So
that's always a good
but,
outcome.
But I
Yeah.
insisted that, wait a second, this is not your get out of jail free card,
Yeah.
that there were no wrecks on the site, and that you got a closure in 1986, that doesn't count.
Mhm.
You've got to look at the risk exposure and of course obligations to provide notice.
Yeah, let's move to transactions a little bit more than we already have, but one of the provisions in deal documents in the purchase and sale agreement between buyer and seller sometimes are negotiated to be the following language, which is, you can do a phase one, Mr. Buyer, but you can only investigate the RECs, the recognized environmental conditions that you turn up in the phase one and do a phase two. In other words, up front, the seller wants to limit what kind of work can be done in a phase two. So you get this kind of a result that's a bit ambiguous in terms of that language in the deal document. All of us, a number of us, more so than others, we do a lot of transactions, either as seller, buyer, lender, tenant, other users of property. And I just want to, I think it's a worthwhile discussion to go through the kinds of things we're seeing turn up in transactions, which some of them are old problems or old issues that are just cast differently. But what do you think are the main things you focus on now with the PFAS thing in mind when you're doing a transaction? And if you can, give us what seller and buyer, and we won't hold you to it.
Well, it's an evolving issue. Michael already hit on a couple of them, but when we're representing the seller, we end up in this debate, well, why do you want to test for PFAS, right? And it's kind of the conceptual site model. Do you have a potential source? Do you not have a potential source? There's some buyers now that just say, well, our lender, our insurance company, we've been told we need to, our environmental consultant, we've been told we need to test for PFAS. Seller says, we don't want you to test for PFAS. So to try and keep those transactions alive, and this is not a new concept, but we're certainly rolling it out a lot now for phase two investigations, we're allowing buyers to proceed with limited sampling, holding them to confidentiality, that they agree that as a due diligence purchaser, they don't have a disclosure obligation to anybody, certainly not to any regulatory agencies, and also asking for confidentiality that to the extent they have test results which exceed any standards, they're not even to disclose those to the seller. Okay? They get to do their investigation. If they like what they see, they can proceed. If they don't like what they see, they can terminate. But that information goes no further than the seller's environmental attorneys, the buyer's environmental attorneys and consultants.
And that's interesting because one of the biggest problems with testing in phase two situations is if you get it to the owner and the owner has the data, then they know what they know. And they may be reporting, I don't think there's a reporting obligation as of now in PFAS and PFOS. We can disagree about that. But then the seller has the data and the buyer walks away. So now if you want to do another deal, you know what you know. And you run into issues of your representations in a deal document that says, I don't know of any XYZ problem. And that's one way that lawyers have set up to try to counteract that issue in the deal. It comes up in every deal, even PFAS and PFOS, not necessarily. But other thoughts on the panel from how are you handling these things? Go ahead.
Well, so I'm seeing the same thing as Ron there, although a lot of times I'm seeing where, we will include language that the seller, will have to provide prior written consent for any phase two testing, and then we will also want to review the scope of work from the consultant. We'll want to negotiate that scope of work to see where testing is going to be conducted, specifically which PFAS are going to be tested for, what testing methods are going to be used. We'll get deep into the weeds negotiating those points. One thing that comes up, though, is if phase 2 testing is allowed, and then the buyer gets results, and it shows. It happened to me recently on a chromium electroplating facility. No shocker there that there was very high levels of PFOS because of its use as a fume suppressant. EPA required it for a long period of time. There was substantial levels of PFOS in the groundwater as well as the soil. So and this was in a state where if the owner has knowledge, then reporting requirements are triggered. Like Frank said, it's state by state. In New Jersey, for example, if the consultant has knowledge, they have to report. So you always have to do a state-specific reporting analysis. But then where things get difficult, like in this situation, is there's high levels of PFAS. The buyer was still interested in the property, but they said, we'll still buy it, but we want it for $10 million less. And then the seller can't say, well, why? We want to see the results, because then if they get them, a reporting obligation is triggered. So that creates a very difficult negotiation then. Eventually in the deal fell through and didn't close, but that's one kind of tricky situation that can develop.
Yeah, but all that involvement in the scope and all that kind of works against the idea that you don't know about it. You've got a whole bunch of back and forth about the scope. One thing I want to say to all the consultants, which you should write down, is that if you go out in phase 2 and you do testing for, I don't know, everything else, arsenic, the usual panoply, PAHs, metals, all that. It's a good idea, in my view, if you're going to be authorized to do PFAS, PFOS, it's a good idea to do that under one set of samples and submit that to chemistry. I think it's a good idea to use a separate water sample and do the PFAS, PFOS. That at least gives you the ability to handle those results differently. If you have to give one to you don't have to give everything to everybody, of course, but I think it's better to have them separated. Any disagreements on that? Phase 2 people, what are you doing about that? I think it's much better, because as you know, the chemistry comes out, you give them one sample and you do arsenic and VOCs and metals and all that, and you do PFAS. You got one custody chain, you got one report from the chem lab, and you can't just pull them apart. They didn't work that way. Anybody run into that before? Well, keep it in mind. Write it down. I think it's a
back
good
of the
thing.
room.
In the back of the room.
Yeah. Who was that raised your hand? Want to talk about it?
I think it's better to limit the entire suite of analytical components to only those things that you actually suspect.
Right. That's true too.
Full record metals and you only suspect arsenic, you open yourself up as a consultant to liability.
Yes. That's a good point.
And likewise with the organics. Only the things that you suspect. It's a very good idea to separate everything that you're talking about into that. But the unseen liability to consultants is horrible, in my opinion.
That's a good point, because in theory, it's because you have data you're generating that's really not needed. You didn't have a reason. Incidentally, the chromium thing, we need to keep that in our kind of list of trigger sites. That's kind of overlooked. All right, so the $64,000 question, and anybody else want to chime in on the topic so far, but the $64,000 question is, do you test or not when you're the buyer? What are you doing? Go ahead.
I was going to say, we've had this panel for 4 years, and my esteemed colleague, Michael Goldstein here, on the very first panel said, if you're the buyer, you absolutely test always. And then the second year, and most everybody else on the panel said no the first year, right? You were average. And then the second year, I joined Michael's bandwagon, and I said yes, test in a specific situation and when you have a specific need. And last year I said the same thing. So this year, I'm still of that mindset. You need to evaluate the facts and circumstances of your transaction, the facts and circumstances of the property that you're purchasing, and maybe as Michael had indicated, maybe you don't need to test, but I'm still leaning towards testing, but not guns a-blazing, but very strategic and surgical. I mean, I on one hand, I have a client that's doing a large industrial development on a former military base, and they want to do a tremendous amount of testing, like $80,000 of testing on the site. And I'm like, I'm trying to talk myself off the ledge to say, do we need all this testing? What do we need? I mean, but the point is to make sure the proposed testing matches the situation. You're building a 500,000 square foot warehouse, spending more than $500,000. Is that my numbers right? $500 million to construct the warehouse. You're grading the site. You really don't know a lot about the specific activities. You're going to be doing dewatering, significant dewatering on the site. There is a need. But I had a regulator tell me, Robyn, only test for PFAS if you want to find it, because you will find it. And I was like, wait. Yeah. And so that has always resonated with me. But my long answer to your short question is yes, I would test.
Yeah, there's an underlying thing that we need to visit here a second, and that is one of the real questions about PFAS and PFAS is it in fact everywhere? We haven't tested enough to know whether it's everywhere. But if it is everywhere, then you got to test everywhere. If it's like any other contaminant, and maybe you don't, because then it's everywhere. But it's like every other contaminant, as Robert mentioned. If you're looking for arsenic from certain operations, if you're looking for chromium or wastewater treatment plant or biosolids, you have a basis for that. But just remember that I think there's a mentality underlying some of these things that you're going to find it everywhere. And that may turn out to be true. I found places that didn't have it. I have. So
you've tested and not found it?
Yeah.
Well, that's good.
Well, at least below the 70 limits.
Okay.
Yeah.
Well, that's good.
I can't remember whether it was point below the 4 limits, but that a lot of people assume that it's everywhere, and I think that complicates that picture. We don't do that with any other contaminant I'm aware of.
Right.
That we think it's everywhere.
Can I say one more thing?
Yep.
And one other thing I would add that's really important in these development sites is you want to test so you have the data to be able to make sure that your construction activities will not make the situation worse. Mm-hmm. So I know we had talked about that earlier, but I hadn't talked about it with the audience is you don't want to exacerbate existing site conditions. That's why it's important to have the data before you do your large dewatering for your stormwater pond. You don't want to exacerbate existing site conditions. You don't want to make it worse. So I just wanted to emphasize that. Go ahead, Michael.
Just real briefly, I continue to be of the mind that you want to test. I have a data bias. More data is better. At the very least, it puts you in the appropriate defensive posture in anticipation of regulators figuring out what they want to do from an enforcement perspective going forward, and allows you to plan better. Forewarned is forearmed. Is that the phrase?
Yeah. And I'll chime in. I completely agree with Robyn and Michael, and I like the idea. Well, I mean, of course, if my client says no, we're not testing, then we're not testing. But I like the idea of testing. If nothing else, then to, like Robyn was alluding to, establish a baseline. Because if you are testing and you establish whatever the parts per trillion are, 100, 1,000, whatever they are, and then for whatever reason you have to test later, and they're much, much higher, you can then kind of analyze, okay, were my activities the cause of this? Was there something on an adjacent property that happened? It gives you more information, to Michael's point. So I like the idea. I like the idea of establishing sort of a baseline.
So one other point, actually, to piggyback both on Ron's comment and Greg's comment, whether you test or not, I think it's in everybody's interest to have confidentiality, right? So understand the reporting obligation in the state that you're in, understand that both parties agree that it's going to be confidential. That benefits everybody. Not only as a buyer is it good to test for the reasons stated, but Greg's example is a perfect potential financial benefit of doing it. You find it if you could get a reduction on the purchase price, and especially if it's confidential, you may not even have to report. So that may work out in your favor. At the same time, if you're a seller, I mean, walls up, as much as possible anyway.
And I guess the only other thing I would add on the buyer side, you know, we have the CERCLA designation is going to go in, it was triggered to go in effect 60 days after publication in the Federal Register, which happened. So now we're just on the countdown till that goes into effect. You all in here are experts on the ASTM 152721, and you know, when PFOA and PFOS are hazardous substances, what that means for considering those as part of doing all appropriate inquiry, and for a buyer to avail itself of landowner liability protections under CERCLA, which is critical for buyers. You know, if you have a facility with a wreck now because of PFAS noted, PFOS or PFOA, you know, testing has to be a consideration for whether you're going to satisfy that standard. I mean, the standard isn't explicit on that. We don't need to get into all the details, but have you satisfied, you know, especially your continuing obligations? If there's wrecks related to PFAS, you don't test and you conduct a massive earth-moving operation on the site. You know, the Ashley 2 of Charleston and 3000 East Imperial cases are two federal court decisions that address the PFPP protection. You know, movement of a site, movement of contamination at a site can be a release. So, you know, you really have to think about, if you're the buyer there, are you getting an ironclad BFPP protection, you know, where there is a wreck now because of PFAS and you don't test?
So
just the fact that, just real quick, Frank, just the fact that there is disagreement and discussion on this issue shows the complexity of it. There's not many issues in due diligence that practitioners on this panel would potentially disagree about or even have different opinions. It's always been pretty cut and dry. We are taking a little different approach with just your typical commercial industrial developer, and we're trying to counsel them on a standard phase one approach. Do you have an indication, do you have a recognized environmental condition that PFAS could be a source of impact on that property that you're targeting? Not the landfill down the road, not the firefighting facility down the road. I've said this before. I think as an industry, everybody in the room, we're all guilty of just gathering data for the sake of gathering data. And you know, Robyn's given some good examples of why it might make sense if you're doing dewatering and regrading. Michael's given a lot of examples of why there's a purpose behind that data, but we're trying to counsel folks on a conceptual site model of what is your trigger for sampling, and what are you going to do with that data, and for God's sakes, how's it going to benefit or kill your deal? There's a lot of thought going into it right now. There's not a final answer. Maybe next year.
A couple of things to make it even more complicated is, if you're representing a buyer, and what do you intend to do with the property? All right, because you have to urge your clients to always think ahead to the next transaction. A lot of development is built to sell, or will be as a basis for industrial sites, or often the basis for lending. You know, so there's other transactional partners that you will have to satisfy in the future. And as we go into the future, what are you going to be seeing when you're working with a lender or a buyer or a tenant? But that's something they have to keep in mind. It's a reason to be more diligent. One of the things, what we've been doing, and I've been doing it all along, from a long time ago, is to say, there's this stuff called PFAS. Obviously a longer explanation than that. And you need to think about testing for it. There's a business risk that I think that, you know, you have to clean, and this is, I'm obviously using a lot of weasel words that I'm not putting in here, but you know, there's a risk here that this could be a problem in the future. You have to decide as a business judgment, and we tell you everything we can. We put the consultant on the phone, everybody talks to them about it so they understand it. Do you want to test or not? As a buyer, I think that's the critical part, and to have the consultant advise the buyer about what kinds of sources are likely on this project. Has it been even a rural piece of property, they had biosolids put on, it could be, So I've always phrased it that way until the moment that it really is regulated. We're getting close to a moment when it really is regulated, no doubt about that. I think it's several years away before Florida, but as Greg points out, it's already there in terms of, with EPA's action, in terms of being a potential CERCLA site. I've handled a lot of issues that way. I mean, there's a number of, what's the name of it, the contaminants that aren't listed, what do you call it?
Unregulated contaminants. Unregulated contaminants.
Unregulated contaminants.
Yeah.
Do we do that with all of those too?
Well, it depends if they're listed. So, EPA comes out with that list, and if they're to be monitored.
So I think the two things to point out to a buyer is that future transactions and the business risk of doing this before, they need to understand that before they go into it, on the property and the testing. Other thoughts? We've kind of done a lot of buyer work. How about seller time? You can still talk more buyer if you want.
Well, just picking up on the last point that you made about the complexity or lack thereof with respect to real estate transactions, the Florida practitioners have spent a lot of time providing, hopefully, meaningful and practical strategies for moving forward with PFAS impacted sites so you can get those deals structured and closed. But the level of complexity increases if there is federal involvement, if there is EPA involvement, and if the cleanup will be conducted pursuant to the National Contingency Plan, where EPA then generates a cost recovery claim or sends out demand letters, 104E notice letters and demand letters, such that now you're dealing with multiple parties in a cost recovery context. There is some movement afoot at the congressional level to provide statutory exemption for certain types of passive receivers, wastewater treatment plants, and the like. Greg, I believe you were speaking to that. I've actually had the good fortune to testify in front of the U.S. Senate on this issue, and what I've proposed is that discussion about a statutory carve-out for passive receivers be extended to any party that enters into a binding voluntary cleanup agreement under a state brownfields program. So the quid pro quo is from a public policy perspective, the public gets a cleanup. It's pursued under state law, and as a result, the feds are shut out. The site isn't cleaned up under the National Contingency Plan. You don't have to worry about CERCLA enforcement actions or CERCLA contribution claims. But until all of that happens, if the feds get involved, it muddies the picture from a 62-780 cleanup and redevelopment perspective.
Yep. There is a memorandum between DEP and EPA about, I think it's further RCRA, it's not just CERCLA, it doesn't cover CERCLA. If you have a brownfield agreement in Florida and you clean up with that, I think, isn't that correct?
CERCLA.
Yes, it does cover both, okay.
It's CERCLA
so
because...
there's a memorandum that says if you clean up in Florida under brownfields, and they won't come get you. How binding that is and how enforceable it is, I don't know, but I think it applies to RCRA and CERCLA, is that right? Go ahead, Greg, did you want to comment?
On CERCLA has a provision under 128B that it's essentially an enforcement bar that EPA says it won't bring enforcement under CERCLA if a party is cleaning up under a kind of approved brownfield program. But like everything else under CERCLA, there's a list of conditions and potential ways you could stumble in there. But I think, as Michael, maybe as you noted, that doesn't provide a defense from contribution claims. So it's the same thing with the enforcement discretion policy that EPA has issued. You know, they're saying, well, we're not going to target like wastewater treatment utilities, or we're not going to target publicly owned airports, farmers who applied biosolids, local fire departments. That's a small universe. And then they say, well, what we are gonna target is PFAS manufacturers, federal facilities, and then, quote, other industrial parties. Well, what fits into that third bucket? That's so broad and vague that, it's a lot of potential sources, and there's a limited universe of who would be subject to enforcement discretion under their policy.
We have a lot to look forward to. Any questions from the, please?
Good morning. I'm an engineer for state of Florida. Work for Department of Corrections. We have a bunch of prisons. I have about more than 2,000 of water plants and wastewater treatment plants. I have a situation somewhere in the Central Florida. We are next to a Air Force base, bombing range, and they have an airport. We're next to it. The nearest distance from them to our water plants and water wells is about half mile. We've seen something kind of odd situation in our water and effluent of the wastewater treatment plant. So for this plant, we treat the Air Force Base's wastewater, and we provide drinking water for them for the past 66 decades for free. And so is there a way for us to communicate, to ask the Department of Defense to test their water for PFAS? Another situation is we have another wastewater treatment plant accepting the leachate from a private landfill nearby for some 30, 40 years. Is there a way for we as a facility, utility, facilities, management facility to require or mandate the customer to treat their PFAS, like in the leachate?
So you have kind of a unique circumstance there, if I understand you correctly. You work for the Department of Corrections, right?
Correct.
Yeah. So you have a couple of sites where you run a treatment system, and you're receiving leachate from the landfill.
Yes, we do. Yes.
And discharge from the Air Force Base. And so you're asking whether you can make those folks test their water. And I think the second part of that question is, should you, for one fun thing, but I don't know how that was set up. Is there some kind of an agreement about how it was set up? It's not it's a public system. The state, for some reason, has decided to take water from these two types of facilities. I think you'd have to analyze that to figure out, but it's certainly not an unreasonable question at this point in history for you to ask for that.
So if you have, it sounds like you have costs to treat, is that right?
A lot.
Okay. So, I mean, just under CERCLA alone, assuming the hazardous substance designation goes through, you may have the ability to sue under that to the extent you have costs. Obviously, it's difficult for us to give legal advice based on your question alone, but there are statutory mechanisms that the state could certainly use to go after the polluters.
Basically, you're downstream from a polluter, just like anybody else who's down. It's this particular type of a release going into your plant.
And again, we talked several times before about 376.313, which establishes strict liability for discharges of regulated contaminants. It sounds to me like you would have an action as we sit here today under 376.313, and McLean brought up an action under 403.412, which is Florida's Environmental Protection Act, which provides for injunctive relief. That could be something you could look at, as well as RCRA, a citizen suit under RCRA.
Okay, well, we have 1 minute left.
Oh, wait, I want to, everybody have the yes or no answer when they test.
Okay, mine was, I advise them based on business risk.
Yes.
And let them make the decision. That's what my answer is, as a buyer.
And that's kind of what Ron's answer was too.
Yeah.
Okay, we have two maybes.
I was a yes.
Yes?
I agree with y'all.
Okay, Greg?
I'm leaning toward yes, put me in that camp.
Lawyerly response.
Yeah, there you go.
Yeah, it depends. Okay, are you, it depends, Nick?
Yeah.
Go ahead. Michael and I are yes. Maybe. No, I'm just kidding.
Okay. Until you're representing the seller and I'm the buyer.
No, Michael's doing good as a
Well,
seller.
I'll tell you something. It's really interesting. The shoe was on the other foot not that long ago. I'm not going to say who, but I'm sitting on the panel. One of our colleagues on this panel and I are on the opposite sides of a transaction where I'm in the sell position.
Yeah.
And this person on the buy position came to me and said, "Hey, Michael, after all of these years of saying test, 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 I'm now in the buy position. Are you going to object as a seller?"
Yeah.
And my response was, no, we understand that you as a buyer have a legitimate interest in understanding what you're buying, so we're not going to object, but we invoked Ron Noble's strategy of confidentiality.
Yes, yes.
So the structure that Ron proposed is exactly the structure that we used in order to be in a position to sign a contract.
There you go. See, our job is to solve the problem in the transaction. That's what most of us do here, a lot of transactional things. So that's it, unless there's one final question. I want to get you out of here so you can get out of your rooms. So that's all we have to say. Thank you, panel.
Thank you,
Thank you,
panel.
Frank.
If I
Thank you,
could,
Thank you, Frank. Thank you.
let me make a couple of quick comments. First off, I want to definitely thank the panel. Do you all realize how much billable hours is sitting up there? Thank you for your time and effort. Greatly appreciated. Real quick, again, I will wrap up, send everybody the videos. It'll be next week because as soon as you walk out the door, you're going to see that the skins have changed.